Hello. This is it. This is the final installment, other than some little extras I'm going to add that I realize were not in here. But landlord-tenant law. Okay, we have a Fair Housing Act. It tells us you cannot discriminate in housing, which is a good deal. It is unlawful to discriminate in rental or sale of housing. You must allow, and a landlord must allow for handicap modifications. And that we cannot discriminate in mortgage lending based on a protected classifications, which we'll tell you later. It is unlawful also to advertise such discrimination. State laws extend protection to additional classifications. Senior housing exemptions are given from familial status discrimination, and HUD is the federal agency responsible for enforcing. There are exceptions to discrimination of housing, but not advertising. An owner-occupied building with no more than 4 units, single-family housing sold or rented without use of a broker, housing that is limited to members of an organization or private club, and buildings open for occupancy after March 1991 must have accessibility for people with disabilities. So litigating housing discrimination. You're going to look at, is the plaintiff a member of a protected class? A protected class includes race, color, religion, sex, familial status, national origin, physical and mental handicaps, and states can give more protected additional classifications. So they must be a protected class, and then the plaintiff must have applied for and was qualified to rent. And the plaintiff was rejected by defendant, and housing opportunity remained available or rented to a person who is not a member of the protected class. If plaintiff establishes the prima facie case, presumption is illegal discrimination. The burden then shifts to the defendant to articulate legitimate and non-discriminatory reason for rejection. If defendant meets burden, it shifts back to plaintiff to show that defendant's legitimate reason was not true, but merely pretext for discrimination. Litigating disparate impact. If policy or practice is facially neutral, but implementation significantly impacts a protected class, it may be challenged by a disparate impact claim. Plaintiff must show statistical evidence that a facially neutral policy or practice causes an adverse or significantly greater impact on members of a protected class. Burden then shifts to the defendant to show that policy related to legitimate non-discriminatory policy was necessary to obtain objective. If defendant shows actions were justified, plaintiffs have burden to show a viable alternative means was available to achieve policy without discrimination. Non-discrimination in housing advertising. Exemptions are available for discrimination in advertising, internet advertising, liability of ISPs and content providers. No. Only if they offered the terms for the discrimination. Discrimination based on an objective, ordinary reader or listener standard as whether a protected group is preferred or dispreferred. That got tricky in multiple choice. Duties of a landlord. Common law rule. A lease is viewed as a conveyance of property. Modern rule, a lease is viewed as a contract. Implied warranty of habitability. The implied covenants in a lease are the implied duty to deliver legal possession, the implied duty to deliver actual possession, caveat lessee, buyer beware, implied covenant of quiet enjoyment, and implied warranty of habitability. Implied covenant of quiet enjoyment. Landlord has a duty not to interfere with the tenant's quiet use and enjoyment of the premises by physical or constructive eviction by landlord or someone holding paramount title. The landlord's duty. Rule. Covenant of quiet enjoyment implied in every lease, except in New Jersey, and this covenant requires landlord to give legal possession. No other person has greater right to possession. This covenant does not protect lessees from acts of others, only acts of the lessor. Modernly, this also includes acts of omission by the landlord that interfere. The landlord has an implied duty to deliver possession. No one else holds paramount title. Landlord has implied duty not to interfere with quiet enjoyment during the leasehold. Duty comes from express lease provisions of caveat lessee exceptions, which are: there is a duty for short-term leases of furnished dwellings, duty to disclose latent defects, duty to maintain common areas, duty to abstain from fraudulent misrepresentation as to conditions, and duty to abate immoral conduct or other nuisance. Then there's breach, the duty's wrongful conduct. Breach, the landlord's wrongful conduct. This could be failure to comply with express lease terms, cannot make fraudulent misrepresentations, must disclose any latent hidden physical defects, has a duty to maintain common areas, and promised repairs must be done in a non-negligent manner. Breach is also a causing of a substantial interference with the tenant's use and enjoyment of the leased premises. It can also be the tenant gave notice to the landlord and allowed a reasonable time for the landlord to cure a defect. The tenant vacated the property with a reasonable amount of time after giving notice of the defect of the landlord who failed to cure the problem. Remedies, actual eviction. If there's actual eviction, you were ousted, stop paying rent. Partial actual eviction, part of the premises is uninhabitable. The majority says stop paying rent. The minority says there can be rent abatement because you can still part of it. Constructive eviction, move out, stop paying rent, but you must move out. Breach must be substantial. I don't need to tell anyone in my year about constructive eviction. If you're watching this later, you have to do some studying on your own because we're not talking about it anymore. We aren't talking about reasonable. We aren't talking about moving out. We aren't talking about law to fact. No more. Tenants must vacate in a reasonable amount of time. Tenants may be required to notify landlord first and give reasonable time to repair. Partial constructive eviction. If there's partial, we're split again. The majority, but we switch. In the majority, there's an abatement, but in the minority, they say stop paying. If you stay, you can sue for damages. Declaratory judgment before leaving will protect the tenant and, I guess, the landlord, both from crazy litigation. Pro tip, if abating and not paying, it's best to give money in escrow to an attorney to show good faith. Plus, then you've got the money if the court says you must pay it. Okay, implied duty to deliver actual possession. The American rule sucks. And it says, no implied covenant to protect lessee against wrongful acts of strangers, either before possession or after. So someone could be living in the house that you just rented, and they're like, sorry. Dirty dogs. Okay, English rule is the majority, thankfully. Implied covenant by lessor that premises shall be open to lessee's entry legally and actually when lease begins, but not after tenant takes possession. So if someone moves into your place, you're going to have to get them out yourself. Damages. How do you measure damages? Difference between rent, reserved, agreed upon, and reasonable rental value. No special damages allowed in this case. So rent agreed upon, but if it's like a shack and it's not worth anything, then they will take that into consideration. Okay. Implied warranty of habitability. This is for residential. Duty of landlord to deliver over and maintain premises that are safe, clean, and fit for human habitation. This means they're free of vermin, they have adequate locks, they're maintaining the plumbing and electric, trash and garbage disposal, and they handle the repairs. This applies to latent and patent defects in essential facilities of rented unit and common areas. A patent defect is one you can see, a latent defect is one you cannot. A latent defect is now considered a patent. Applies to defect present at outset as well as subsequent deterioration of the premises based on statute or judicial decision. Most jurisdictions extend to all forms of housing, but are not commonly extended to commercial tenants. They must be fit for habitation, safe, sanitary, weathertight, mostly addressed by housing codes. Latent and patent defects, covered. Latent becomes patent once discovered. Uniform Landlord and Tenant Act. The landlord has a duty to comply with applicable housing codes and to put and keep the premises in a fit and habitable condition. And these statutes and judicial decisions include Section 8 housing. They may cover all or only some types of residential leases, but commonly they do not extend to commercial leases. Breach varies by jurisdiction, may be based on housing code violations. Tenant must notify landlord and give reasonable time to remedy. There is no waiver is allowed for these statutes and judicial decisions. No breach if defect is the fault of the tenant. The remedies are to terminate the lease and collect damages, stay in possession, burden on landlord to sue for possession and back rent. Tenant can withhold all or partial rent. Tenant can repair and deduct. Tenant may pay reasonable rental value, but the calculation varies. Tort damages, discomfort and annoyance, infliction of emotional harm, punitive damages. Then we have caveat lessee, buyer beware. Only duty to landlord is to deliver legal possession of property and the tenant's promised burden to pay rent. Exceptions. When landlord wrongfully interferes with the tenant's quiet enjoyment, tenant can abandon and stop paying rent because that is constructive eviction. Here the landlord has no duty except short-term leases of furnished dwellings, duty to disclose latent defects, duty to maintain common areas, duty to abstain from fraudulent misrepresentations, and duty to abate immoral conduct and other nuisances. Remedies. Rule. Actual or constructive eviction is wrongful act by the landlord which deprives the tenant of beneficial enjoyment or actual possession of the leased premises. Actual eviction. Stop paying rent, get ousted. Rule. Actual eviction occurs when landlord wrongfully outs T from physical possession. Partial actual eviction. Eviction from part of the premises is actual and allows T to remain rent. Majority says stop paying rent. Minority says abatement of rent. Wise choice, pay rent in escrow to an attorney until legal proceedings dictate what must be done. Constructive eviction, move out and stop paying rent. Rule, no physical expulsion or exclusion of tenant by landlord's wrongful act substantially and materially deprive tenant of beneficial use and enjoyment of premises. Tenant must vacate to claim. Breach must be substantial. Tenant must vacate within a reasonable time. Tenant may be required to notify landlord first and give reasonable time to repair. Partial constructive eviction, the majority says abatement of rent. The minority says stop paying. Pro tip, escrow the money. Assignment or sublease. Two approaches to decide. All or less than all is transferred. If all is transferred, it's an assignment. If less than all is, it's a sublease, even if a reversion is 1 day. And we look at the intent of the parties. Right of reentry. Minority treats as a sublease. This is also in California. So if there's a right to reentry, it's a sublease. Privity and landlord liability. Primary equals privity of estate. Sublease severs at tenant and does not go to T1. So a sublease severs privity of estate, severs it. That's covenant to pay rent, covenant to keep in good repair. The secondary is privity of contract, and that stays with the primary tenant unless there is a novation, which means the assignee will, or subletter will take on those things, those promises. Third party beneficiary theory. When T1 expressly promises to assume covenants under original lease between landlord and tenant. It's third party beneficiary theory. Contract leases, assignments, and subleases. If nothing is in contract Property may be assigned to a subletter. Absent provision saying otherwise, leasehold is freely transferable. Lease as a conveyance is freely alienable. If contract says consent is needed for sublease or assignment, a lease is a contract. So implied contractual duty of good faith and fair dealing, implied covenant of good faith and fair dealing may impact landlord's ability to withhold consent unreasonably, especially residential. Any restriction will be strictly construed. The majority or common law says consent can be withheld arbitrarily. Minority says lesser may withhold consent only if commercially reasonable objection. This could be financial responsibility, suitability or legality of the use, need to alter premises, nature of occupancy, good tenant mix, projected success. Unacceptable reason would be personal taste. This is blank. It's one less page I have to go over, right? Yes. They can say no. They cannot say no because of convenience or sensibility or general economic protection, because if they don't let you sign it, then you would breach and then they could get a higher renter. Clause only protects the landlord in ownership and operation of property. Contractual provisions. Lease may expressly provide that all transfers are prohibited or that consent to transfer can be arbitrarily withheld. Clause dealing with capture of profit upon transfer. Clause providing consent can be arbitrarily withheld. Clause absolutely forbidding assignment or subletting. Validity of assignment if forbidden. The majority of states treat transfer without consent as effective, but will still breach lease, which is a problem because then you just sublet it or assign it to someone who's now going to lose it because you breached. Termination of lease. Abandonment and surrender. Surrender by mutual agreement of termination might need a writing by a notary. If the surrender is by a tenant, they need to notice, offer, and abandon. Abandonment is an offer by the tenant to landlord to surrender and terminate lease. Common law abandonment gives the landlord the choices to accept the implied offer as a surrender, so you don't have to pay rent. Refuse to accept, rent is still owed. And you can do anticipatory repudiation, which is immediate damages for future rent. And then there's the re-enter or the landlord can re-enter and relet, which is called mitigation. Here the tenant is responsible for money differences if the new renter is paying less or it takes time to get the new renter in. The majority says you must mitigate. Anticipatory damages cannot be punitive, so you've got to kind of have a good idea of what it might be. If vacancy is one of many in a apartment complex, it has to be treated equally as vacant stock. And commercial reasonableness are allowed in good faith when you're looking at someone to move in. Landlords, if they want to terminate, they must notice or eviction or summary proceedings. So there is retaliatory eviction, which is not okay when landlord retaliates for complaining of violations to authorities. There's constructive eviction, substantial interference to cause tenant to leave. There's self-help eviction, locking the tenant out. Must include both elements to be able to do this, otherwise it's wrongful. The two elements are the contract must specify right to re-entry and it must be peaceable. Judicial eviction is the legal process. Summary eviction, modernly in all states, forcible entry and detainer and unlawful detainer. Majority require resorting to a legal process. But the minority, there's the English rule, which is reasonable force, and there's the minority of the minority, which is peaceful self-help, which we don't have any idea what that is. And then simple recovery of possession based on failure to pay rent, shortened form of ejectment, no damages. Notice of termination is required for periodic tenancy. The common law says 1 month for a month to month and 6 months for a year to year, but statute basically says 30 days for month to month and maybe 2 to 3 months for year to year. Some just say 30 days. Insufficient notice may be effective at earliest possible date of next rental period, and it may be ineffective. And last but not least, there's a little snippet on security deposits. The landlord has the incentive to keep the deposit. The Uniform Residential Landlord and Tenant Act penalizes landlords who wrongly refuse to refund. Ladies and gentlemen, that is property